we can argue back and forth whether or not may jurisdiction ng ICC, and the reality is nandun na si President Duterte. But for future cases, I want to know whether the ICC can issue a warrant and then pwedeng idiretso na silang i-expel, i-deport, or whatever we call it. And
Siguro, Secretary Remulla, you are aware about yung dalawang dissenting opinion na sinabi ng dalawang miyembro ng pre-trial chamber ng ICC na nagsasabi na yung jurisdiction, about temporal jurisdiction, ang magti-trigger lamang ng investigation is yung paghihingi ng pag-request ng permission ng prosecutor to the ICC. At ito'y ginawa nila 2 years after nag-effect yung ating withdrawal from the ICC. Ginawa po nila yan, 2 years. Kaya nga, dalawang dissenting opinion yun eh. So sana, kung tayo, if you want to interpret itong mga bagay-bagay na ito, sana we have to interpret it in favor of our people.
Yes, maraming salamat. Maraming ibinunyag nung nakaraang hearing. Kaya't mag-umpisa tayo kay Secretary Remulla with a very simple question. Is the Constitution the supreme law over all other laws? Simple lang po.
Yes, ma'am.
So it is also supreme over all other treaties.
Yes, ma'am.
Kapag nagkaroon ng conflict sa Constitution at yung Rome Statute, alin ang maghahari?
The Constitution prevails.
Kapag may pag-iiba sa saligang batas at yung RA 9851, alin ang mangingibabaw?
Ang saligang batas po.
Parati ang saligang batas, di po ba? Maliwanag ho yun. The President has been saying that the country was just complying with obligations and commitments to the Interpol in arresting and turning over the former President to the ICC. For the nth time, liwanagan na lang natin, a red notice from the Interpol is not a warrant of arrest. Is that correct? Perhaps the PCTC can help us here.
Tama po kayo, Madam Chair. Ang red notice po ay hindi siya ang warrant of arrest.
At ang pagka-alam ko, nung November 21, 2024, may nakita ako pero hindi ko na mahanap ngayon, biglang nawala sa ating website, sa DOJ website, isang legal opinion tungkol sa UAE na sinasaad na hindi maaring ang Pilipino ay hindi hayaan umuwi, ano? Maliwanag po 'yun. Kaya't nagtataka ako kung baka naman si Attorney Chan may kopya pa nun kasi ikaw raw yata yung author. November 21, ito tungkol sa UAE to. Walang kinalaman dito sa kay PRRD.
Good afternoon, Madam Chair. I do not recall having issued a specific opinion on that date, Your Honor.
Would you recall number 50? A memo number 50. It's no longer in the website for some mysterious
opinion
reason.
number 50?
If you could just look it up, we'd be very grateful.
We'll
and
get
we'd
back
like
to you
have
on
a
that
copy.
within the afternoon, Madam
Sige,
Chair.
Attorney Chan, maraming salamat. Ngayon, yung tinatanong ng lahat, yung obligasyon sa ilalim ng isang treaty, ibig sabihin ba, ligtas na sa ating Bill of Rights, sa mga karapatan pantao? Ibig ko sabihin, kapag may obligasyon ng Pilipinas sa ICC, sa Interpol, do we still have to comply with the Bill of Rights that guarantees the rights to the accused and to the arrested?
That's a given.
Certainly, the Bill of Rights is there precisely to limit the powers of the government, and if the government can circumvent the Bill of Rights by just entering a treaty, then the rights guaranteed under Article 3 of the Constitution are no longer secure, hindi po ba? So, can compliance with the ICC obligations allow the government to disregard the Bill of Rights? Hindi po ba? Maliwanag po yun. At for the same reason na talaga ang nangingibabaw sa lahat ay yung ating konstitusyon. So kahit papano napilitan na maaresto at itangay ang dating Pangulo sa ICC dahil daw sa ilang obligasyon, pandaigdigan, kinakailangan talagang sumunod pa rin tayo sa ating saligang batas, lalo na yung Article 3. Talagang sagrado po yun, di po ba? Yes.
Yes, ma'am.
So, ang tanong namin at tanong ng lahat ng sambayanan, bakit ang pamahalaan, ang administrasyon, hindi muna kumuha ng court-issued warrant galing sa Pilipinas bago inaresto si Presidente Duterte? Why didn't the administration secure a court order before flying the President out of the country? Nung last hearing, may sinasabi si Secretary Remulla na yung nangyari surrender, hindi extradition. At hindi katulad ng extradition, sa surrender, hindi kinakailangan mag-issue ng warrant of arrest para damputin ang dating Pangulo. Tama po ba yun? Kasi yun ang sinabi nyo dati nung
Mga extradition kasi, hindi ho natin pwedeng gamitin dito sapagkat hindi tayo pwede mag-file ng extradition dahil nasa atin po yung tao. Ang extradition po na sinasabi ng batas ay yung court o yung arresting state. Yung state pala na may warrant ang mag-file ng extradition sa Pilipinas. Kaya surrender lang po talaga ang option natin. Wala ho tayong ibang option.
Kabisado ko po yan. Panahon pa ng tatay ko, yung extradition law natin. Ako yata nag-type nung bata. Ang tanong dito, under surrender, there's no need for a Philippine court to issue a warrant. Ang sabi po ninyo. That's the stand of the government. Is that
Opo,
correct?
iyan po yung aming stand.
Does this not contravene the Bill of Rights that we've already agreed upon as being sacred and above all else, particularly the right of deprivation of liberty without due process,
Yung due process
and
po
the right
kasi,
of liberty of abode?
kasi ang due process po dito, yung sa issuing body, yung nag-issue po na warrant of arrest if they observe due process. Ang alam po natin, 7 taon pong inimbestigahan itong kasong to, nagbigay po ng notice to sa mga kinauukulan na maaari nilang kasuhan. At pinayagan sila sumagot. Alam ko po yan na binigyan sila ng notice, may mga tanong na binigay sa kanila, pinayagan po sila sumagot. Kung ayaw po nila sumagot,
7
is
taon
our own
ito
look
sa
what.
ibang bansa, hindi 7 taon dito sa Pilipinas.
Opo, habang tayo po isaklaw ng ICC,
Hindi pa rin saklaw yan sa ating batas.
Hindi,
Kasi
ano ho?
ayon sa ating batas,
Hindi, habang tayo po ay saklaw ng ICC, binigyan na po ng due process yung mga tao.
Madam Chair.
Yes,
Can I interject?
Senator De La Rosa, please.
May I know from the good secretary, saan kayo nakakuha ng information na yan? Na yung mga
Ganun ho kasi
souvenirs
ang
binigyan ng tanong, pinapasagot yung mga akusado. Saan po kayo nakakuha ng informasyon na yan?
Tsaka sinusubukan po nilang kausapin. Yun po yung alam ko. Talagang
I'm asking about yung sinabi mo kanina.
natural po yan,
Binigyan.
nakalakaran, kasi kahit anong korte po, ay binibigyan ng pagkakataon na sumagot ang tao sa mga paratang sa kanya.
I was not.
Senator Bato, nakalista ka. Binigyan ka ba ng pagkakataon noong nakaraang 7 taon na sumagot sa anumang alegasyon?
Meron nag-communicate sa opisina ko na gusto akong kausapin. So that's it. Hanggang doon lang.
Siguro hindi
Kinausap
dapat
niyo ba
na
ho?
due process.
Kasi kung kinausap niyo, marahil ay sinabi na sa inyo yung nais na sabihin.
Bakit ko kausapin? Sinabi mo na nga na hindi niyo recognize yung jurisdiction ng ICC. Kayo mismo, from DOJ. Ilang bisis mo sinasabi noon, Madam Chair, na hindi na recognize. Ako pa, i-recognize ko na ako mismo ang kinakasuhan? Kayo
Meron
na
ho
nga,
kasi-
gobyerno na kayo. Kayo na nagsasabi na hindi nyo na-recognize. Bakit ako pa mag-recognize?
Meron po kasing residual powers ang ICC. Yung po
Sabi
yung
ninyo, 1 taon lang yung residual power.
Oho,
So,
pero
bakit
yung
2019 to 2020,
yung buong ano ho,
bilang
yung
nyo?
buong panahon na dumaan mula 2011 hanggang 2018, ito po ay panahon na meron pong jurisdiction ng ICC sa ating bansa, sa ating mga citizen. Ngunit katapos nun, nawala na ho yung itong, hindi na ho na natin maaring kilalanin sapagkat umatras po tayo sa pamagitan sa ICC nung iretras po ni President Duterte noong 2017 na naging effective lamang noong 2018.
Madam Chair, if I may.
Yes, Senator Bato.
Siguro, Secretary Remulla, you are aware about yung dalawang dissenting opinion na sinabi ng dalawang miyembro ng pre-trial chamber ng ICC na nagsasabi na yung jurisdiction, about temporal jurisdiction, ang magti-trigger lamang ng investigation is yung paghihingi ng pag-request ng permission ng prosecutor to the ICC. At ito'y ginawa nila 2 years after nag-effect yung ating withdrawal from the ICC. Ginawa po nila yan 2 years. Kaya nga dalawang dissenting opinion yun eh. So sana, kung tayo, if you want to interpret itong mga bagay-bagay na ito, sana we have to interpret it in favor of our people. Tao natin ito eh. Pilipino ito. Bakit natin papaboran yung mga foreigner na mga banyaga na yan? Sila na nga nagsabi. It was the request for to conduct investigation was triggered 2 years after nag-effect yung ating withdrawal. But then again, Madam Chair, I will leave it at that. Please continue.
Yes, Senator Cayetano, please.
Just a manifestation on that point, and of course, our friend, the DOJ Secretary, can rebut or give a retort. Magandang hapon po sa inyong lahat. Justice Ascuna, thank you very much po for giving us time and being here today. Actually, isang main contention siguro yung residual power sa case sa Supreme Court, and as the Justice Secretary said, it's sub judice, and of course, everyone will be waiting for the decision of the Supreme Court. Ang point ko lang kasi, both sides, the pro-Duterte, anti-Duterte, want accountability. The pro-Duterte feels that the accountability is the drug lords, etc. And if President Duterte did something that amounts to a crime, pero ang accountability dapat dito sa Pilipinas at tamang proseso. So doon naman sa gustong i-hold, anti-Duterte, gusto siyang i-hold accountable, siguro naman it's safe to assume that they also want yung tamang proseso. So the thing is, there was an actual Supreme Court case, the Pangilinan versus Cayetano, questioning, I think the Secretary of Foreign Affairs noon, kaya named, questioning nga yung kung kailangan ng Senate concurrence yung withdrawal ng natin from the Rome Statute, no, from yung ICC. Pero nakalagay din dun sa case na yon, let me paraphrase, that the Supreme Court can continue to review yung actions nung executive. So my problem with yung interpretation dun sa residual powers, kasi nga, di ba, sa 5 judge sa ICC, yung 2 nagsabing, wala kaming jurisdiction. Kasi nung sinimulan namin yan, tapos na dun sa residual na 1 year. But 3 justices said na pwede. So my problem kasi is walang World Supreme Court eh. So there's only the ICC Court, then the Appellate Court. Unlike kung dito natin final sa judiciary natin, then yung interpretation, whether they still have jurisdiction or not, would have been done under Philippine law. And President Duterte would have been able to present his case not only as to jurisdiction, but as to whether or not there is probable cause. So I'll stop there, Madam Chair. And again, I think this is a point of disagreement, but I just like to manifest that, no, that we can argue back and forth whether or not may jurisdiction ng ICC, and the reality is nandun na si President Duterte. But for future cases, whether it's Senator Bato or others named, I gave 2 examples, no? If suddenly there's a witness from Marawi and they said that our troops killed children and women, and then nag-issue ng arrest ang ICC, or if the military suddenly uncovers a mass grave in any part of the country and says na nilibing yan during 2011 to 2015, I want to know whether the ICC can issue a warrant and then pwedeng idiretso na silang i-expel, i-deport, or whatever we call it. And And I guess in the finality, Secretary, is that the Supreme Court will rule on that. No? But just to clarify matters, I want to put that on record. That's what I want clarified, Madam Chair. Thank you.
Maraming salamat kay Senator Cayetano. Gusto ko lang ipaalala, and I think Executive Director Alcantara is here. In the diffusion notice, if we will recall, on the second page, apakaliwanag na nakalagay with a view to extradition. Walang binabanggit na surrender. With a view to extradition and assurances given that extradition will be sought. 2 beses inulit ng Interpol to. Extradition is explicit. Secretary Remulla, kung obligasyon natin, ang obligasyon natin, extradition. Pati yung Interpol, yan ang sabi.
Sila ho ang magka-file ng extradition, hindi po tayo. Hindi ho namin option yon. Yung po option po nila yon. Hindi namin option yon. Kasi ang option lang po namin, surrender lang. At sasagutin natin ang extradition kung sila po ay mag-file.
Liwanagin
Under the law po.
Liwanagin natin, ang surrender option kapag foreign national. Ang liwaliwanag po niyan nandito sa ating batas at hindi rin kayo nag-intay ng request for extradition. Even though only 12 to 15 hours as measured by
Wala pong particular
General
reference yung 9851 sa foreigner. Ito po ay sa offender lang ho, sa accused. Yun lang po ang reference ng 9851.
Makikita natin, kasi kinalkal na natin dito sa Senado, nanggaling rin sa Senado yan, na ang nakasaad sa Article 17, yung dulo, RA 9851, talagang maliwanag na surrender para sa foreign national. Ilang beses na rin pinaliwanag ni Attorney Medina yan sa first and second hearing na maliwanag na para sa foreign national yan. Kaya mukhang malabo ito.
Sa interpretation po yun, hindi ho sa batas yun.
Nasa transcript po, ang liwaliwanag, may amendment si Senator Subiri at the time, nakalista lahat ng bill spending, pare-pareho po ang referral sa foreign lang, hindi po pwede sa Pilipino. Hindi bale, tulad nga ng sinabi ni Senator Cayetano, we agree to disagree, hindi po pwede para sa amin, maliwanag. And I'd like to call on Justice Ascuna at this juncture. Reference has been made to RA 9851, yung Article 17 nga na sinasabi, na sa ngayon, hindi na yung Rome Statute kasi post-2019 na tayo. No? So, ang huling kataga, pursuant to the applicable extradition laws and treaties. It's very clear, it's the last sentence of Article 17. And in an interview, the former Supreme Court Justice Adolfo Ascuna opined that surrender must be made pursuant to an applicable treaty. And since the Philippines is no longer a party to the Rome Statute, what then is the applicable treaty? Wala nang treaty. Dahil ang ini-invoke nga yung Rome Statute, wala na ngayon. Siguro si Justice Ascuna mas mahusay magpaliwanag.
Thank you very much, Madam Chair. Regarding the applicable provisions, the justification given by government for the surrender of former President Rodrigo Duterte to the ICC consists of two grounds. One is the warrant of arrest issued by the ICC and served through the protocol of the Interpol. The other is Section 17 of Republic Act 9851, which is the Philippine IHL law, and which provides that if a person is already being investigated for the crimes covered by this act, which includes crimes against, which includes the crimes for which President Duterte is being charged, is already being investigated by an international tribunal. The relevant Philippine authorities may surrender such person to the international tribunal, but it adds pursuant to the applicable extradition laws and treaties. Ngayon, ang tanong, ito bang last sentence na ito which provides for the requirement that the surrender should be pursuant to applicable treaties, is still applicable since we don't have anymore the Rome Statute. Sa palagay ko po ay it's either we have the Rome Statute or not. If we don't have a treaty, then we cannot surrender the suspect to the ICC under this section, because this section requires that the surrender be pursuant to a treaty. Pursuant means in accordance with. And so if there is no treaty, in my view, we cannot make a surrender. On the other hand, if there is still a treaty that is due to the residual obligations that the Philippines may have even after withdrawal, pursuant to Article 127, Paragraph 2 of the Rome Statute, after withdrawal, the withdrawing state still obliged to cooperate with the ICC in relation to matters already under consideration by the court prior to withdrawal. So again, you go back to the question, is the Philippine situation something already under consideration by the court, by the ICC, prior to our withdrawal? In my view, Madam Chair, the answer is yes, because as of February 8, 2018, prior to our withdrawal, Fatu Bensouda, the former ICC prosecutor, already said that the Philippine situation is under preliminary examination as of that date. The question is whether or not the prosecutor is the court, because 127 paragraph 2 says under consideration by the court. And in my view, it is, because there are four principal organs of the ICC. The first is the presidencies. There's one president and two vice presidents. The second are the judicial divisions. The third is the office of the prosecutor. And the fourth is the registrar. So the office of the prosecutor is part of the court. Therefore, when Article 127, Paragraph 2 says the matter must be under consideration by the court at the time before withdrawal, it includes consideration by the prosecutor. And so therefore, I believe we have residual obligations even after withdrawal. Question therefore is whether or not the warrant of arrest issued by the ICC after our withdrawal is something we have to cooperate with. Under 127 paragraph 2, in my view, yes. And therefore, in my view, the warrant of arrest is legal. However, I believe that the surrender is not, because the surrender must be pursuant to a treaty, and therefore our own law, Section 17 of Republic Act 9851, brought back the Statute of Rome, even after withdrawal, because it requires that a surrender must be pursuant to the applicable treaty. And therefore, in this case, the applicable treaty remains the Statute of Rome. And thus, we have to follow Article 59 of the Statute of Rome, which requires that the custodial state, namely the Philippines, must first bring the arrested person to a local court to determine two things: whether or not the person is really the one named in the warrant; second, whether or not the person has been informed of the charges against him or her. This was not done. Therefore, there was, in my view, a violation in the act of surrender. However, Madam Chair, this is in the forum of the Philippines, but in the forum of the ICC, different rules apply. The rule in international law, Madam Chair, is that procedural laws are governed by the forum. So procedural safeguards are applicable only to the forum. If the Philippine Bill of Rights, for instance, which says that no person however, criminal proceedings before the ICC is governed by their own procedure. This is in accordance with private international law, that procedures governed by Lex Fori, the law of the forum. And therefore, we go to the procedure in the ICC. In the ICC, I believe they follow what is called mali coptus beni detentus, meaning that even if the arrest is illegal, the detention can be legal. It does not automatically mean that if the arrest was illegal, the person arrested must be released. They will balance, it's a balancing act. They will balance the illegality of the arrest with the need to prosecute someone for very serious offenses under international law. And in their view, the balance weighs in favor of prosecution. They will prosecute, notwithstanding the violation of the procedure in the arrest and in the surrender, I mean. Therefore, it depends on whether you're talking about Philippine Forum or the ICC. The ICC, I believe, will follow their own procedure, whereas in the Philippines, as it is now pending in the Philippine Supreme Court, in my view, there is a violation and there will be consequences for that violation. Thank you, Madam Chair.
Thank you very much, Justice Ascuna. As usual, we received a very exhaustive opinion, and I'm certain that we will be guided by the same.